So, Asha, is Hunter Biden out of options?
Eh, it's complicated. I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal contributor for ABC News.
And I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And we're here to help you understand topics that can't be boiled down into a soundbite or a tweet. Okay, so we need to come clean with our viewers / listeners because you and I had a big strategic fail last week.
Yeah, it's an understatement. We decided to record on Tuesday morning for a podcast that was going to be released on a Friday, and the jury was in the middle of deliberations, and yet we were talking all about the Hunter Biden potential verdict. It was a kind of a mess.
Yeah, and then the verdict came out, and then we looked at the transcript of our recording, and it was like, wah, wah, it's just not something that we could release. And then it turned out that we just couldn't find another time to record because it was my son's graduation week from high school, and I had family in town, and I think, Renato, you had stuff going on, and our producer had stuff going on, and so we apologize.
Indeed. So what we're going to do is take the best parts of our analysis and work them in here in our first segment, talk about the Hunter Biden verdict now. But we spent a lot of time last time talking about what if there is a hung jury and what does that mean and blah, blah, blah. That's just not really relevant. So we do have a verdict, Asha. The verdict is guilty. I don't think it's a shocker because it was literally, did he fill out a form falsely? And of course, the form was false, and there's a lot of evidence of that. But that's not really the end of the road for Hunter Biden. I think, one thing we had a fulsome discussion about in our Phantom recording is how this is all part of like a broader strategic move by him. And really a lot of that is going to occur on appeal.
Yeah. So just to recap, this was a conviction on 3 counts. One count of making a false statement on the form itself. The other was a false statement to the firearms dealer. And then the third was unlawful possession of the firearm itself. In other words, for the period of time that he owned the weapon while he was an addict, which is illegal. And so, yeah, let's talk about, before we get to the appeal, what are we really looking at? Because we talked about this, I keep referring to our Phantom episode. We did cover a little bit what, the possible penalty might be. And I always feel like federal sentencing is like this weird, it's a mystery to me. So it's not clear exactly what, he's a first-time offender. This is a nonviolent offense. He didn't do anything with the weapon. On the other hand, I assume unlawful possession of a firearm is a pretty serious offense, even if the false statements pieces are less serious. So what are we even looking at here?
Sure. So a couple of things. You're right about federal sentencing. This is an area where journalists fail constantly because usually what they do is they talk about the maximum possible penalty. Mm-hmm. They stack it up, all the counts, like there often be like 20-year maximums for each count. And so they'll be like, Paul Manafort faces a maximum of 190 years in prison or something insane. And the guy gets like 8 years. Okay. At the end of all that. And people are like scratching their heads. Well, I thought he was facing 100 and something years. The reality is the statutory maximums don't really mean a lot. The issue is going to be, what is the federal sentencing guidelines? But then even there, the federal sentencing guidelines are just what they're called. They're guidelines. And judges are free to depart from those. And they usually do or often do nowadays.
And they can depart upwards and downwards, correct?
That's right. But they usually depart downward. And that's particularly the case for non-violent offenders. And that's really a movement in the guidelines. There's become an increasing movement for defendants who don't have a criminal history to get non-custodial sentences. That's been a trend. Now, you're right that unlawful possession of a firearm can be a serious offense. But in my experience, usually this particular statute's not charged. And we've discussed that, I believe, in the past, Asha, that possession of a firearm while being addicted to narcotics is not usually the charge. If there's a gun charge brought federally, usually it's felon in possession of a firearm. And there, the driver is often the criminal history of the defendant and the circumstances under which they possess the firearm. In other words, because I've done a lot of those cases when I was a federal prosecutor, a lot of times we were taking on those cases because the person would have a violent history, like they had been convicted of first-degree murder or something, and then they're out on bond and they've got a gun, something along those lines. Or they're a gang leader and they have a whole slew of convictions related to that, maybe conspiracy, narcotics conspiracy and other things. And we find them with a firearm, but we know that they're essentially part of the Gangster Disciples or Latin Kings or something like that. Here, that's none of that's present for this guy. And the circumstances under which he possessed it are also not problematic. It wasn't like he was out on bond. It wasn't like he was running away from a police officer, throwing the gun from his hands as he's fleeing. It's nothing like that. It's a case where I think the guy had it for under a month, right?
11 days. 11
days. Thank you. And so, given all of that, I really points to a non-custodial sentence. And I would feel and what I mean by that is no prison time. Now, I would feel very confident about that if this was a person coming to me seeking legal advice and their name was like Hunter Rangappa or Hunter Mariotti. Given that his name is Hunter Biden, it complicates things because the judge may feel the necessity of sending some sort of message, general deterrence here, that no one's above the law. Even if your last name is Biden, even if you're the president's son, you can get a sentence and go to prison. And so he has more of a risk because of his name, ironically, than for the actual offense itself.
Well, I'm glad there's at least one judge who wants to send a message on that principle that no one is above the law.
I hear you. I feel like I've gotten the sense, I don't know, because I can't get inside these judges' heads. But one thing I will say is both of these judges, there's two judges, he's facing a second trial, which we could talk about, in tax charges on the whole other side of the country, on the West Coast. But both judges were eager to move this case forward quickly. There was no desire to delay this. There was an eagerness to get this done before the election, I think. And I will just say that is not typical for cases that are charged in federal court in the United States. In other words, I handle cases across the country. I have cases that were charged in 2020 that still haven't gone to trial yet. And so the fact that these cases are tried quickly suggests to me that these judges are concerned about how the public perceives the criminal justice system and views this case as a lens by which that can occur.
Yeah, and I just want to point out on the principle that no one is above the law and the vindication of that principle, which I think was very important. Sorry, it sucks for Hunter Biden, but at the end of the day, he got a fair trial and he was convicted by a jury. I don't think this is you agree with things when it sides with your side and you disagree when it doesn't. It is what it is. But what I think is really interesting is that the very fact that this verdict vindicated that principle really set right-wing Twitter ablaze because it was like they short-circuited, the brains short-circuited because, the narrative is that this is a two-tier system of justice and it's been weaponized against Trump and, against Republicans and to try to sabotage him. And so there was really no way, if you're engaging in that kind of directional motivated reasoning, that, to reconcile this. So, of course, we saw the emergence of a conspiracy theory, which was that this was all an op.
Yeah, to distract from the real
This
crime.
is an op. Everybody's in on it. The Trump-appointed judge, the Trump-appointed U.S. attorney who Biden held over, the jurors, and they're all doing it to protect Biden and provide cover for the fact that Biden really is trying to go after Donald Trump.
Yeah, or engaging in some more serious crime. I heard this sort of conspiracy theory that actually Hunter Biden and his father were conspiring to do something much greater. And so they've charged Hunter Biden on this narrow crime. Rather than, I'd say the more obvious implication would be this is what they had. They charged him with these fairly
after 5 years.
After 5 years,
at the 11th hour, right when the statute of limitations was about to expire.
Right, very narrow charges that candidly would not have been brought against others. I mean, if it was just some random person, Hunter Mariotti, I don't think that they would have charged that person with these crimes. But it is what it is. So, one thing I will just say, because I do think that people may wonder, we were talking about the strategy a moment ago. A lot of people may say, well, why did Hunter Biden go to trial? Why didn't he plead guilty? And I really think that this was nonetheless absolutely the right strategy for Hunter Biden.
Because of the appeals issues, or that because there was still the hope? I mean, this is in the Phantom episode we talked about, kind of the narrow but possible path that, he's a sympathetic defendant and could have potentially gotten a hung jury. But he also has some strong issues on appeal. Right.
So a few things. So first of all, yes, there's always a chance of a hung jury. He's, like you say, sympathetic defendant. He's a Biden in Delaware. You never know. There's always a shot of that. Secondly, as you just alluded to, Asha, there are appellate issues, which you're going to walk through in a moment, I think. There are appellate issues. In order to plead guilty and preserve those appellate issues, it requires an agreement with the government. And it's not clear the government was going to be willing to make that agreement. And even if they were, going to trial creates appellate issues. So if you really think there's a good chance you're going to get 0 years in prison either way, or very low sentence, like if you think basically your sentence is going to be whatever it is anyway, you might as well go to trial, create all these potential appellate issues there that arise from the trial and how that's handled. And then also delay, because at the end of the day, too, another play's got to be for Hunter Biden that, hey, my dad is not going to be in office forever. He may end up, if he's a lame duck, either a lame duck president because he loses or because he wins and he can't run again. He may just commute my sentence anyway. So delay is good.
Though we can come back to that in terms of the second trial, because that trial is going to take place in September, the one on the tax charges. And I am assuming that if he is convicted there, then this conviction will play into whatever sentencing is considered there. So that's a bit of a gamble, it seems like. I mean, the pardon and commuting thing still stands. I mean, in that sense, but I'm just talking in terms of kind of risk reward of the trials themselves.
When you face multiple trials, and he's not the first person that this has occurred for. Obviously, Trump is in this situation. We've talked about it. There's Michael Avenatti, R. Kelly. There's plenty of people who have been charged all over the country. Whenever you're in that circumstance, it's a difficult position for somebody to be in. You're essentially fighting a war on multiple fronts. You want to have the weakest trial first. I think that happened for them. This is the one that they had a better shot at a hung jury. I don't know what they're going to do in the other case. They also have issues that they're raising there, appellate issues. But at the end of the day, the judge in both cases are going to be considering the outcome of the other case in their sentencing. And ultimately, what's going to likely happen is one sentencing will go first. The judge will pronounce whatever sentence. And then really the other judge is just going to be considering, do I add anything to it? In other words, I'm going to impose a sentence. Do I just impose a concurrent to Judge so-and-so's sentence? Or do I say, X amount of it is concurrent and then 6 months of it are consecutive or 2 months are consecutive? And
that's what happened in the Manafort case, that part of the, I think part, not all, but part of the second sentence in the, I forget which one went first, Virginia or, but in any case, whichever one went second was, the judge said could be served concurrently with the first.
Right. And that's very common. And sometimes there'll be a resolution, after the government wins the first trial, sometimes the defendant will plead guilty in the second case with an agreement that all the sentencing just occurs in courtroom number one and you just have one sentencing. I don't think that's going to happen here for a variety of reasons. Some of which we discussed: delay, appellate issues, et cetera. And there's no lack of resources. I mean, a reason to do that is in part like for a lot of people, it's like, do I want to spend another $1 million, $2 million in legal fees or whatever it ends up being, fighting another trial that I'm likely going to lose and doing a second sentencing, yada, yada. But for Hunter Biden, that's probably not a concern either.
So let's talk about appellate issues. He raised 2 issues before the trial, which the judge said could not be raised until after the trial was over. And that was on selective prosecution. And then there was a Second Amendment issue.
That's right. And we could talk about both of those. There's also, I believe, an issue that's been raised about whether or not, like, there's already been a deal struck with the government. Right.
Yeah.
Which I think you and I both agree. I mean, one thing that I'll just say is I think everyone who listens to this podcast knows by now, I was a federal prosecutor for a long time, but I've also been now a criminal defense attorney for a long time. I often file motions that I think are likely losers to put a certain narrative in front of the judge, so the judge understands kind of my perspective on the case. And one narrative I sure as heck would tell here if I was Hunter Biden's team is, we had a deal with the government to basically wrap all this up and get basically nothing for this guy. And then they dropped it at the 11th hour because they effectively, in their view, and Hunter Biden's view, they had to change heart in prosecutor side, and they wanted to, because of public pressure, they wanted to make the deal tougher against Hunter Biden and prosecute him after the fact for some other crimes. That's the way that they're going to portray it.
Well, and it does seem to play into the selective prosecution argument, I would think, because it wasn't even a plea deal. On the gun charges, it wasn't a plea deal. It was a non-prosecution agreement.
Right.
In other words, it was a diversionary agreement that if Hunter Biden did XYZ rehab, I don't even know what the conditions were, but the Department of Justice would not prosecute him. And that's different than a plea agreement where you're actually admitting your guilt to a crime and you're just doing it, rather than go to trial. In return, the prosecution gives you maybe a more lenient sentence. So the fact that I think he could point to, well, in terms of the plea agreement, I think what you're saying is it's not going to go very far because the argument that it is binding is not going to go very far, the legal argument, because clearly there was not a meeting of the minds. And we don't have to go down the rabbit hole of what went wrong, but basically it was not structured properly and it wasn't clear what the U.S. attorney was willing to take off the table. Hunter Biden thought they were taking everything off the table, and the prosecutor said, no, we still want to investigate some other stuff. And then it was like, no deal. So there was no meeting of the minds. But I think that some of those terms does play into the second argument, which is that this never gets prosecuted. And in fact, the Justice Department, wasn't even going to prosecute me.
Right. Exactly right. And so I do think that those are narratives you would always put in front of the judge. Like, one big thing, if you're on the defense side, is typically, the Justice Department wins almost all their cases. And in most cases, there's absolutely overwhelming evidence and the cases are very straightforward and so on and so forth. Like, your client's caught, robbing a bank with a mask and a gun in his hand or something, or, there's 5 pounds of meth in his car and they arrest him in the car with the meth or whatever it is. And so the judges are used to the government just always winning and there being there often aren't a lot of issues. And so they're going to give a lot of weight to what the government says. And then they're going to presume that the government's going to win. And so it's really important, if you have a case that's not like that, and you're a vigorous, defense attorney, you're going to put that all in front of the judge. So, typically, the Justice Department would never take the position that they have a completed deal unless it's all signed and inked and all done up in court. But if you've got any argument that you had to deal with them, you're going to make it. If there's anything that they're doing that's shady, I mean, a selective prosecution motion is a total loser. Like, the standard is super high because courts would face them in every case.
They don't want to get into, they don't want to, they're not going to go and second guess things that are
correct. Unless there's no probable cause, like there's literally no evidence you did this and they're just like making it up, which maybe may preview our second segment here. Unless you have that circumstance, it's not colorable at all. Like courts are just not going to second guess that sort of thing. Like, oh, they want to prosecute this person rather than that one. So those are losers, but they're great narratives to get in front of the judge. You absolutely will color the judge's view for the trial in a lot of cases and so forth. So, and impact sentencing, because the same judge who oversees the trial and considers these motions and so forth is also the judge that will sentence the defendant. So painting that picture from the beginning is very important.
Yeah. So then let's go to that third Second Amendment issue, which does seem to be, it has some legs, it seems like, for a number of reasons. This relates to, I think, and you can disagree, I think the Second Amendment argument would only go to the unlawful possession charge. I don't think anything that, even if it went in Hunter's favor, would impact the false statements pieces.
I think that's right. I mean, there may be one thing that I have not looked at. So this is just me reacting, having done legal work. Is there a materiality requirement for the false statements? In other words, if I lie about whether I just farted, okay, that may not matter to the on the federal form that I'm filling out or whatever. It's got to be something that actually relates in some way to what that something that somebody might actually care about or so forth. But I don't know in this context whether that even is required. So my gut is you're probably right, but they may have some argument on it. But yeah, this is likely going to just relate to the 922 account, the possession, the possession of the firearm.
Yes. So this goes to a possible challenge, a likely challenge that Hunter Biden will make, that the actual federal prohibition on drug users possessing firearms is unconstitutional under the Second Amendment. And he is going to draw on, I believe, a recent Supreme Court case called Bruin versus New York, which invalidated a New York handgun restriction. And basically, just to simplify the court's reasoning there, they said that firearm restrictions under the Second Amendment, that you have to be able to find a similar restriction or some sort of analog to the restriction that existed at the time of the founding, at the time the Second Amendment was created, in order for it to be valid today. Yes. That is really the standard. And as you can imagine, that calls into question a lot of possible restrictions. So there's actually a case, as of this recording, pending in front of the Supreme Court that has challenged the restriction on domestic violence offenders possessing firearms. That was argued this term, and we are waiting for that to come out, United States versus Rahimi. And from what I understand, when I was following the oral argument, it seemed like they weren't biting, and so it'll be interesting to see if they uphold that restriction, how they distinguish it. But just to say that there's this spectrum, let's say best case scenario, in my opinion, they uphold the domestic violence offender restriction, but they've invalidated, this New York restriction. Like what would fall, in there? And, the prohibition on drug users owning firearms, I think, is an up in the air question, especially by someone who is not otherwise dangerous or has no other record. And in fact, another circuit, the Fifth Circuit, has struck down this particular prohibition as applied to someone who was caught with a firearm who had in the past used marijuana. The Fifth Circuit is not binding on Delaware courts. The Delaware courts are under the Third Circuit. But I think the pathways here, it seems to me, Renato, are he appeals this to the Third Circuit. If the Third Circuit says, no, this prohibition is constitutional, then you have what's called a circuit split. In other words, you have a Third Circuit saying one thing, you have the Fifth Circuit saying another. It's the kind of case that the Supreme Court, that is warrants the Supreme Court stepping in. Or the Third Circuit takes the same route as the Fifth Circuit, which, then would be a win for Hunter. Is that kind of how you're gaming this out?
That's right. And obviously, this, for what it's worth, I mean, the government could appeal from the Third Circuit's ruling if it wants to. But, that would be a difficult position to be in for the government if you have two courts of appeals. When we talk about circuits, we're talking about courts of appeals that are broken up into circuits, depending on the area of the country. If you have two courts of appeal in different parts of the country that both came out that way, that'll be tough for the prosecution. So very viable appellate issue there. And then, separately, I will just note that the judge is going to sentence Hunter based on a conviction on all of those offenses. She could try to separate it out and say, I'm giving X months for this and X months for that. She could also say, this doesn't matter whether there's an offensive condition. I'm considering his conduct. And regardless of whether that statute, like to try to moot it effectively or make it like less palatable for them to fight, basically say, I'm going to give him X months no matter what, or I'm going to give him probation no matter what, no matter which of the counts of conviction hold. But, judges sometimes do that to save themselves time. But in this particular case, maybe she doesn't. Maybe she wants to not prejudge anything and just say, get pronounced a sentence here. And then it'll be interesting to see whether if there is a sentence of incarceration, whether or not, she allows him that to be essentially stayed pending appeal. And in a case like this, where there's a viable appellate issue, sometimes courts will allow that to happen.
Yeah. And if this goes to the Supreme Court, it'll be really interesting because you basically have the court, at least the most conservative members, looking at a conviction of a Biden. Bruin, actually, that the New York case was, the opinion was written by Thomas. So there's a part of me that would just love to see Alito and Thomas having to grapple with the application of their originalist argument, and this very conservative argument as applied to Hunter Biden. And I think their heads might explode.
Well, I think, as you pointed it out, I mean, there's going to be convictions on other counts. There's also potentially, we don't know what's going to happen in the tax case, but that's also a problem for Biden because at the very least on misdemeanors, he certainly didn't pay certain taxes on time and blah, blah. So there's some, he's going to have some issues there as well. Okay. You can't dispute certain things. So they may just, they may decide whatever they're going to decide in the Second Amendment and which provides a win for Biden on one count, but Hunter Biden, that is, but not on the others. And we'll just see what his father does, because typically speaking, just to give a sense of the timeline, typically speaking, after a trial, then there's post-trial briefing and the judge is going to decide that. And then there's going to be an investigation by the probation department, which we just had in Trump in the state court, but it's much more fulsome in the federal setting where you're going to have, he's going to meet with probation officer. There's going to be sentencing memorandums going to be prepared on both sides. There's going to be a full-blown sentencing. Then the judge would generally have, or even if there is a custodial sentence, there'd be a report date. So it's very likely that Hunter Biden would not face any sort of requirement to report for a sentence of incarceration until Biden's second term in any event, or at least until after the election. Keeping in mind, of course, that there's also, given that there's another trial, the judge is not going to be scheduling the sentencing in the middle of the other trial. So, or right before that. So I think there's going to be a lot of room for Hunter Biden to push this into a second Biden term or until after the election in any event, which would give his father an opportunity to intervene, which I will note Joe Biden said he will not do. But obviously that's his son.
Yeah. Trump tweeted that he would.
Yep. I hear you on that. We'll see who ends up being correct in that, but I wouldn't be surprised if Hunter Biden and his team are definitely considering that possibility. I certainly would if that was my client. So, Asha, Trump is not taking the news that he's become a convicted felon very well. It's going quite badly for him. He's very reportedly very upset about that.
If we want to take this challenge, get into his brain for a second and how he sees the world, and it's important to remember that he sees the mere cloud of suspicion as being a huge weapon that can be wielded against a political opponent, right? I mean, when Hillary Clinton was under investigation, he, milked that to the hilt during the campaign, and was threatening to appoint a special counsel after he was elected. And having learned from that, during his first term, he tried to create that cloud of suspicion in that perfect phone call with Vladimir Zelensky. So in other words, he sees like this whole criminal, justice process as being like, tantamount to guilt. So you can only imagine that actually going to trial and being convicted, like I'm sure he was going crazy just having all these charges over him, even though he's managed to, make money off of it and fundraise off of it. But I am sure that now it's like he's been reverse Uno'd.
And speaking of somebody who does not play Uno, I don't even know what that means, but it sounds very bad.
Yeah, reverse Uno is when you kind of like somebody like gets you and then you reverse Uno them and you get them back.
Oh, wow. Okay.
Like, in other words, he got reverse Uno'd by his own strategy in the sense of like, this thing that he thought was going to be the downfall of his opponents is now something that he himself has been subjected to, except the only difference is that it's legitimate in his case.
I feel like I just got reverse Uno'd because I was the guy when we had the segment about board games talking about how much I love games and board games.
Uh-huh.
Me and my wife go to game show and you're like, I'm not really into them that much. And yet you came up with a card game that I haven't played since I was like 8 years old. And I was like, did not understand the reference. So kudos to you on that.
Thank you.
Asha.
Thank you. I'm sneaky that way.
You are. You have reverse Uno'd me. But in any event, yeah, I mean, I think so. Trump is, he's going out there. So supposedly, reportedly, he has made calls to the Speaker of the House saying Congress needs to get me out of this, essentially. And, Speaker Johnson has got a 1-vote majority, I think the Republicans have in the House. He's basically hanging on because the Democrats think he's more reasonable than the alternatives and are helping him stick around. And he said that he wants to help Trump, but there's not a lot of ways to do it. I mean, one of the supposed options that's been floated is a bill that allows presidents to remove their case to federal court. I'm not sure whether you could do that retroactively.
I don't think you could do that retroactively.
wouldn't think so. Even if you could, I don't know that that's going to change anything. Having an SDNY, a judge, federal judge in the Southern District of New York, take a look at this. I don't think they're gonna just be applying, New York law in the same way. I don't really think that's going to help Trump all that much anyway. So yeah, I mean, Trump does not have an easy way out of this.
And once again, I just think it just tells us more about what he sees, like how he views our institutions. Like he doesn't see them as like independent institutions that actually have a purpose, like separate and apart from himself. Like they're all extensions of himself that exist to serve him and his interests. That's the thing, is like Congress is there to help him get out of trouble. Like, Daddy Fred is no longer in the picture. Daddy Vladdy is preoccupied. Now he's got to go to, I guess, Daddy Mike in the House. But it really gets to, I think, imagine that this is what he wants the Republicans to do in Congress when he's not president. So once he is president, and particularly when he's in control of an entire branch of government, I think this should really, I mean, if your alarm bells have not gone off by this point, I'm not really sure like what there is to do, what there is to say about it. But, he's been advertising this, and we have this whole Project 2025 game plan, which basically I think this kind of is in that vein.
Right. I agree with that. And I mean, I will just note too, I mean, it's also doesn't understand federalism, right? In other words, the United States House is not going to, it's very challenging for the United States House to do anything about a state conviction, which is why they're trying to come up with some creative way to say they helped Trump. And of course, the Senate and the current president have something to do with whether a bill becomes a law, which we all learned in junior high with the cool song about that.
With
Schoolhouse Rock. Thank you for that reference. So yeah, I mean, I think it portrays a lack of understanding, but I do agree with you that the bigger concern and issue is we've been seeing increasing reporting coming out about Trump's plan to unleash retribution via what he's calling lawfare against Democrats and other people who he perceives as anti-Trump. So the idea being that he is going to, I mean, or the reporting, I should the idea, the reporting is that he's essentially going to target people, George Conway or whoever Democratic operatives he doesn't like, and say, I am now going to, bring criminal charges against them for what I don't know, or being critical of their leader, I suppose, or their leader in waiting. I don't know what that would be. But he's essentially going to impose the costs or what he views as the embarrassment or whatever, impose them on those people.
Right. And, what we thought during the first term, which is, there's too many buffers and barriers and guardrails that would prevent the institutions from, being co-opted in that way, I don't think are going to hold anymore. I mean, so, normally the FBI has the Attorney General guidelines that require, certain factual predicates before they can open an investigation. And you have to document all your evidence, and you work with a U.S. attorney, and you, have to go through all of these different stages, except he is planning to purge the civil service. I don't even, he wants to essentially dismantle the FBI or maybe replace agents with his, lackeys, I guess. The FBI does not have a legislative charter. The FBI operates under rules and regulations promulgated by the Attorney General. So if someone like Kash Patel becomes the Attorney General, he could theoretically just rescind the Attorney General guidelines or rewrite them or change them. Like, you can open an investigation on whoever you want. And basically then, what we're left with are these additional, hurdles that we have as part of due process and that exist in the judicial system. Hopefully the judges will uphold that. They still have to go through grand jury or, present a case. But I mean, honestly, can you believe we're talking about this?
Yeah, it's crazy. I mean, I've definitely contemplated what happens if Trump becomes president and he starts prosecuting people for essentially committing thought crimes or whatever it ends up being, non-crimes,
fabricating evidence,
whatever it is. And what would I do in this circumstance? And I think I would probably try to find a way to help defend those people in court. Mm-hmm. And that's challenging. I mean, it's challenging to do. It's expensive. And the question is, will our legal system, will our institutions hold our criminal justice system in the wake of that? It'll be very interesting, and it'll be a test of the founders' plan for the Constitution, having lifetime appointments for judges, having an independent judiciary, having a jury system. I mean, trial by jury is supposed to be a check on government. The idea is you got a bunch of random people and they've got to unanimously agree. It'll be very interesting to see if that happens, but it's a nightmare scenario that I hope does not happen because it would be so horrible for our country.
Well, and then also don't forget the pardon power, which is another internal check on, federal government employees engaging in wanton and deliberate misconduct is, the possibility of being held to account themselves. And, a weaponized Justice Department would not choose to pursue, for example, let's say, agents or prosecutors who lie to court, right? Like, if you don't have anyone who's willing to actually go after them, then that's not really a check anymore. And even if you had someone, when you have a president who can simply pardon them, even pardon them, proactively, so that they don't even have to be held to account, what you're creating is a system that incentivizes complicity.
Yeah. It's a very scary thought. I mean, pardons would certainly, like you said, they would certainly prohibit essentially prosecutions for false statements, perjury, all sorts of other things. Even if the judge sua sponte raised an issue of criminal contempt, it would really only be, I think the only possibilities left would be civil penalties, which often are not sufficient, and particularly if the government is going to bear the cost of defense for somebody that really often doesn't deter. We would really much be relying on goodwill. And if people and our founders understood that you couldn't do that we weren't angels. And so because we weren't a group of angels up in heaven, we needed to have structures and checks and balances to ensure that, and separations of powers to ensure that you didn't have a subversion of the system by they viewed as men, of course, with evil intentions.
Yeah. And this is also why we have background checks, and we ensure that people in positions of public trust are suitable. I mean, even to be an assistant U.S. attorney, you have to go through a background check, and you have to get cleared, I think, at the secret level, I think. Is that right? Do you get like a clearance of some kind, or is it just kind of a basic?
There's definitely a background check. I don't think you need clearance, but there's a background check.
Again, that's something that can simply be overridden if you have someone in the Oval Office that just doesn't care.
That's right. I mean, certainly if a lot of the usual procedures and regulations are out the window, then that can be changed. There's a lot of preparation going into that. I mean, the prospect is maybe like someone like Jeff Clark or John Eastman being Attorney General, right? Somebody like that who's already shown corruption and literally people who are facing the disbarment, potentially becoming the Attorney General of the United States. I will say, another thing that I think that this really underscores is that we are now, given the timing, it's now late June. I think realistically that the ballot box and mobilizing in an election is going to be the only alternative to Donald Trump doing this. In other words, I will tell you, Asha, I was going through all my old emails because I've got some stuff with my career I'm doing, and categorizing all of them. And I saw an email from one of our listeners from a year ago telling me, I practice law in Florida and you are so way too pessimistic about how in this case is going to go to trial. It's going to go to trial, but before Labor Day for sure, blah, blah, blah. This is from a year ago. That turned out to not be true. In other words, my cynicism and skepticism was on point for that one. The reality is nothing may go to trial for Donald Trump before the election. We don't know, but I certainly wouldn't put a lot of money on that happening. And really, this is ultimately going to be an election that is going to determine our country's future.
It will indeed.
So, Asha, before we go, I noticed earlier during our recording your amazing nails. Unbelievable. Those are awesome, by the way.
Thank you.
Are those a graduation?
Yeah,
decision?
They were. I got my nails done and I wanted something bright and fun. This does not relate to his school colors or anything like that.
Okay, that's what I was curious.
No, I'm going to Ocean City, New Jersey, and I just thought that the color is called Frozen Wave.
It's totally ocean themed. But then I also noticed, and you see it now, a cast on one of your hands. What's going on?
So I started getting shooting pains up my arm, emanating from my thumb and then like this side. And I think it's, I went to Dr. Google myself.
Dr. Google, my wife does that too. It's like WebMD or something. I'm like,
I know.
that.
I go to Dr. Google, and I think I have texting thumb. Like,
what is texting thumb? I've never heard of texting thumb.
So when you text, and especially if you're, I'm bad because I don't use both thumbs. I just use one. So I'm kind of like hold my phone, and so you're using a lot of like fine muscles when you're doing that, and too much strain is bad. And then I think I've also been on my laptop a lot, and so anyway, like I've got big problems. And so I just decided to self-treat.
Well, I hope that works. That's crazy. I do use both now. I mean, I don't think about it, but I do use both thumbs. I bought one of those mega iPhones that, you know what I mean? The ones that have like, that are bigger. So I can't really get my hand around it. It forces me to use both thumbs. And I sometimes use voice to text. So maybe that helps me. I don't know. Wow.
I've been texting with my pointer finger.
That must be very slow.
It's very slow. So sometimes the AI, figures out what you're trying to type, and you can just start punching the words.
And sometimes it gets
what time will you be home? Like if you do like what time, it'll just give you the rest of the.
Mine says whenever I say thanks to somebody, it goes Thanksgiving. Like it's not always right, but whatever.
But yeah, so that's going on. And what did you do for Father's Day?
Nothing very exciting. I have a lot with my job I'm dealing with right now. So I had to spend a lot of time indoors. Talk to my dad who lives in another state. I always on Sundays. I always hang out with my mom and have breakfast with her every Sunday. So I did that.
Did you get celebrated as a stepdad?
To a very minor extent. So, to a very minor extent, being a stepdad to a teenager is a tough job.
Yeah. My dad's here. He's 82.
That's awesome. I think it's so important. My relationship with my parents is very important to me.
MSW Media.